Okay, good afternoon, everybody, and welcome to this webinar hosted jointly by Tilleke Gibbins in Bangkok and Clyde Co in Singapore. Before we begin today, one small housekeeping point. As we have a very large number of attendees today, our speakers will be answering questions at the end of the session, and you can submit those questions at any time by typing them into the Q&A box, which you can see at the top of your screen, a little speech bubble with a question mark in there. Okay, so before we get started, I'll just give a brief overview of the framework for today's discussion. We'll be beginning with an overview of the arbitration landscape in Thailand. That will be given by Nopramat Tamatira who is a counsel at Tilleke Gibbins here in Bangkok. Nopramat's an experienced litigator with over 20 years of experience of trial and appellate advocacy at all levels of Thai court, and as well as substantial experience with international litigation and arbitration gained from numerous cases around the region, especially in Singapore, Cambodia, Myanmar and Laos. Particularly sought after for her arbitration experience, she is known for her skilled navigation of both international rules, particularly the UNCTRAL, SIAC, ICC, HKIAC and GAFTA rules, and domestic rules. That's both within Thailand and in other regional countries across Southeast Asia. She's a prominent member of both the Thai Arbitration Institute and the Thai Arbitration Centre, and is a regular speaker on arbitration. Her presentation will be followed by the first speaker from Clyde Co. That will be Prakash Pillai. Prakash is the managing director of Clyde Co Classis and a partner in Clyde Co in the Singapore office. He was recently appointed managing director of Classis LLC, which is the associated firm of Clyde Co in Singapore. He focuses on dispute resolution and international commercial arbitration across a multitude of sectors, including corporate commercial, insolvency, trade and commodities, construction and engineering, and the employment sectors. He's also appeared before various arbitral tribunals in both ad hoc arbitrations and arbitrations governed by the leading institutional rules. As managing director of Classis LLC, he also represents clients in commercial litigation matters before the Singapore courts. Described as measured and strategic by Chambers Asia Pacific and recommended as a leader in India by Legal 500 Asia Pacific, Prakash is recognised as a leading lawyer for his expertise in international arbitration. Leading industry journals such as Chambers Global, Chambers Asia Pacific and Global Arbitration Review and the Legal 500 have commended his knowledge and expertise consistently. Following Prakash, we'll be moving over to the next speaker from Clyde Co Classis. That's Junsiang Ko. Junsiang is the legal director of Classis LLC in Singapore. Again, that's the associated office of Clyde Co for Singapore. Junsiang's main areas of practice are litigation and arbitration disputes, with a particular focus on shareholder disputes, employment, financial fraud, and regulatory investigations. Finally, we will be moving to Tawat Damsaad from Tilleke Gibbins here in Bangkok. Tawat is a partner and senior litigator in Tilleke Gibbins Dispute Resolution Group, and is widely regarded as foreign investors' attorney of choice for legal conflicts that directly impact their future business operations in Thailand. Particularly renowned for his arbitration work, Tawat has acted in some of the most significant arbitration cases in recent Thai history, as well as some of the most significant cases challenging foreign arbitral awards in the jurisdiction. And he's extensively recognised by international publications and directories, including the Legal 500 and Chambers Asia Pacific. So with those extremely impressive profiles out of the way, I'm sure you'll agree with me that there's nobody better to address the topic today of the enforcement of foreign arbitral awards in Thailand and the challenging and setting aside of arbitral awards in Singapore than the team we have assembled today. With no further ado, I will hand over to our first speaker, Nopramat, over to you.
Thank you, Sax, for your introduction. And okay, so let I share my slide now. Good afternoon, everyone. So today I will talk about this agenda. So when we have the clients who obtain the international arbitral awards. They come to ask us how they can enforce this award in Thailand. So this is the topic that I like to discuss with you today. Okay, first, what kind of requirement are the documents and the steps to enforce the foreign arbitral award in Thai court? And then the second topic, that what kind of the objections that the respondent usually made in Thai court in order to prevent the enforcement to be proceed. And then we will discuss about whether or not if the award had been announced in the at the seat, and whether or not the Thai court can enforce this award, and any grounds of the refusals to enforce the award. And then Kun Thawat, my colleagues will discuss about the case in Thai court concerning the enforce of the award and the refusal of the enforce of the award. This also includes whether or not the Thai court can re-examine the merit of the case, right? And it's kind of the question that most of the clients ask us, whether or not whether or not how Thai court interpret the arbitral award, and the notion of the public policy that widely interpreted in Thai court concerning the enforcement of the foreign award in Thai court. So I start with the landscape about the enforcement of the award in Thailand. And this is the statistic in at the end of December 2019. And in Thailand, when you obtain the award, right, the arbitral award, you may go to the first the international the intellectual property and the international trade court. We call IPIT court, right? And if your case, if the award is against the state enterprise or related to the public service, then this will be under the administrative court. So this statistic only obtained from the IPIT court only. So as you can see that it shows that the 50% or the 52% that the application made to the IPIT court for set aside the arbitral awards. However, this statistic didn't separate between the domestic arbitral award and international award, right? And 29% is the request to enforce the arbitral awards. And how about other things? The other percentage, where did they gone? So it's possible that after the parties obtain the arbitral award, they may make the payment according to award. Therefore, they don't have to come to enforce the award in the court. They're not required to request the court to make the order for the recognition and the enforcement of the award, right? Okay, another statistic, how Thai court make the decision based on this application. So this application, the 50% Thai court lose 50% for dismissal. What that is mean for the dismissal? In this case, that if the party requests for the revocation of the awards, 50% the court refuse. So it means that the court enforce the award. So, and the set aside is only the award that lose in Thailand. So because Thai court cannot set aside the award that is international award. And the 20% is the enforcement. So the higher percentage is shown as Thai court make the ruling favorable to the arbitral award. Here, the statistic based on the judgment and the order in the case for the application and enforcement of the awards. The party who obtained the award and the respondent deny to comply with the arbitral order, then the claimant will submit the application to any court that believe that the respondent have the asset. For example, the Singaporean claimant obtained the winning award and want to come to enforce this award in Thai court, right? So in this kind of case, the Thai courts make the rulings unfavorable by enforce the award 75%. I think that this outstanding percentage is very clear that Thai court give the assistance to the party according to the award that rules by the tribunal. So only 17% that for the dismissal. In this kind of dismissal is mean that probably the application is defective. The application is not according to Thai law, then Thai court dismissed this application. But for the refusal, 48% of the refusal of the enforcement, so it means that this will be based on the ground of the five grounds under Thai Arbitration Act. For example, if the arbitral award rules that beyond the arbitral agreements, or the arbitral award is contrary to Thai law, that is something that Thai court can refuse to recognize and to enforce the award. So let's say if you are the foreign party, you want to, or even though you are Thai and you obtain the winning award from other country, and you want to enforce these awards against the respondents in Thailand, what kind of the documents that you want? Actually, under the Arbitration Act of Thailand, it said that you only need the arbitral award, and then you need the arbitral agreements, and the third things that you need is the Thai translation of the award. Yet that it seemed to be very easy, right? So, but in the real life, that is not true, because there are so many things that you need to prepare. For example, apart from the three things that I asked you, that yet for the arbitral award, sometimes the arbitral agreement sometimes is included in the underlying agreement. So then you will need to incorporate the underlying or disputed agreement to your application for enforced award as well, right? And if the arbitration clause includes in the or if the arbitration clause include in the dispute agreement, you need to point out in your application to the court that, okay, in which section and the detail of the arbitration clause to the court. And also, it is advisable that client should also prepare these selected documents to incorporate into the application for enforced awards, like the notice of arbitration, response to notice of arbitration, and key pleadings. This should be sufficient at the first step of the submission, and after that, after the respondent obtain your application for enforcement, the court will order the respondent to submit the objection, and after that, we, as the claimant lawyer, we may ask you to, in case respondent raise the issue that this award is not final or is being announced in the country as this, something like that. So in this case, we also ask client that they should provide us the judgment of the court where the final award issues to confirm that no set aside of the award. This is a very important document, because sometimes clients just thought, okay, then they obtain the award, then they go to Thailand to enforce the award. So I think that if you believe that the respondent not going to fight with you in the country that issue the award, then I think you go to register the award in your court before you come to Thailand. Okay, and other documents that you can prepare, it should be rely on the issue that raised by the respondent. So it just like the arbitral procedural memorandums, the arbitral interim order, this kind of thing, in order to prove that the tribunal have done the good job, have give the fairness to both parties. So it's also depend on what is the objection made by the respondent. Then you need to prepare the evidence to rebut that objection. So the step for the enforcement in Thai court, we file the application or petition to for the enforcement to Thai court, and then the respondent file the objection. And after that, the court can schedule for the witness hearings that allow both parties to bring their witness to testify. But to testify in this case is the court, Thai court, in the past 10 days, past 10 years, the court may allow for some kind of the to scrutinize the merit of the case. But this day, I think it's very rare that the court will allow the witness to testify on the merit of the case, unless it is about the issue of the public policy. This thing can give the channel to the respondent, try to show the court about the merit of the case. And then the court will grant the order whether or not to enforce the arbitral award. And if the party is not happy with the order, they can go to they may be entitled to appeal to the Supreme Court. So there will be two levels of the cost for enforcement of the arbitral award in Thailand. For the normal case, usually it takes like 7 to 8 months from the filing date in order to obtain the Thai court order to enforce the award. So this is the example for the common objection that the respondent usually makes in Thai court. This is some example. It seems unbelievable, like claimants defective power of attorney, something like that. So, for example, the person who signed the POA, not the authorized director. So this is something that we usually draft the instruction for how to make the power of attorney for Thai court, like a page, something like that. And the second most common is that sometimes, because the award also consider the evidence that have to put the duty stamp, and the respondent said that, oh, this award is not have duty stamp, then the court should not consider this award as the evidence in the case. So this is unbelievable objection in Thai court. And another thing is that for sometimes the respondent raised the issue that the tribunal ruling irregularity rulings, make the irregular rulings. For example, like the tribunal not give the fairness to respondent, not allow the respondent to adjourn the hearing, or the tribunal not admit some documents in the case, something like this. And the fourth common issue that the respondent say raised the issue that they never received the final award. In Thailand, Thai court usually raise the issue that, okay, to make the notice to the party, you have to send by registered post, something like that. And lastly, that is very common one is that the award contrary to Thai law and the Thai public policy. So my presentation will finish here, and I leave it to my colleagues from Clyde Co to present about their Singaporean laws. Okay.
Good afternoon, gentlemen. Yeah, thank you, Norpramat, for the very enlightening presentation. So she had sort of set out some of the problems with enforcement and so on, and that is certainly one of the issues that you've got to consider. It's one of the challenges in international arbitration, going through a process of which is very intensive, requires an investment and so on. And at the end of the day, enforcement is what helps you realize or monetize an award. And if you can't enforce it, or you have difficulties doing that, it kind of stains the entire process. It makes it much more difficult for you to, even engage in the process of international arbitration. So where the assets are, something that you have got to look at closely, and you've got to look at enforcement regimes. But on top of that, the thing that you've got to be aware of as well is, the issue of setting aside arbitration awards. And for that, you've got to look at the venue of the arbitration, which is usually set out in your arbitration clause, which will say, the venue or the seat of arbitration shall be in whichever country. So this presentation is focused on Singapore. We're telling you about what the approach is in Singapore in relation to this question of setting aside an arbitral award. Now, the very fact that you can set aside an arbitral award is something that may make you gawk, because you think that arbitration awards are meant to be final. The whole point of going to arbitration was that you didn't want an appeal. You wanted to sort of create a process which was based on contract, away from courts, and you just wanted, to sort of tailor it in the way that you saw was the most efficient way of adjudicating any kind of dispute. But ultimately, while you can do that to a great extent, there's still an element of regulation by the courts of the seat of the arbitration to ensure very broadly that there's fairness or procedural fairness. And if you can somehow show that there wasn't, there may be an opportunity for you to apply to the court of the seat. And in this presentation, we're talking about Singapore, for an order to set aside an award. And that's something you've got to be very mindful of, very careful about, in the course of the arbitration. And in Singapore, you have 3 months. It follows the model law, where you have 3 months from the date of the award to initiate such a challenge. So the next, I'm going to talk about the philosophy or principles that underlie or underpin setting aside in Singapore, and how the Singapore courts approach these issues. Next slide. So I was talking about finality, in arbitration, it's a built-in mechanism almost. There's some seats that allow some limited recourse to appeals. London is one of them, where you can appeal an arbitration award on the basis of error of law. But Singapore follows quite strictly the model law, which says there's no right of appeal. And that means that even if the tribunal gets it wrong, it makes an error of law or fact, you've got to sort of accept your arbitration as you find them, whether they're good, bad, or indifferent. You have chosen them as a matter of contract, and you've got to live with that choice. It stems from the whole concept of party autonomy, or freedom to contract, because what underpins an arbitration, arbitration is a creature of contract. It's a clause within a contract that gives jurisdiction to a tribunal to adjudicate a dispute. That jurisdiction, the basis of that jurisdiction is party, consenting to the tribunal to do that. And parties with their autonomy, are able to then devise a suitable process to make an arbitration as efficient as they would like it to be. And it comes, of course, with many advantages: confidentiality, flexibility, and so on, speed and efficiency. Speed and efficiency, there's a premium to that. It's also one reason why you want finality in an arbitration award, because you basically have decided that you don't want various layers and tiers of appeal that can take you months, if not years, to sort of finally get to a conclusion on your dispute. You want it done fairly speedily before a tribunal. You may even sort of agree to an expedited procedure, and you want finality. Finality gives you that speed. So that's why it's very, very important to sort of look at this issue from that vantage point, because it sort of cuts against the sort of the notion of finality, when you've got an opportunity to set aside an award which would displace what a tribunal has found and put more time on it, and that's something that you've got to be aware of. Now, setting aside is not an appeal, though. The court is not concerned with substantive merits, but it's rather about the process. So it's here to sort of look at the process of arbitration and to ensure that it's regulated to the extent that it's fair. It's not looking to replace its own view of the merits, replace the tribunal's view of the merits with its own. It's meant to just look at procedural issues. Next slide. So we will come to the specific grounds in a bit, but generally in Singapore, setting aside is a court application. So again, we were talking about arbitration moving away from the courts, doing something which is private and confidential. But for issues of setting aside, and similar to sort of enforcement and dissent, this is where there's an interface between the arbitral process and the litigation process. Ultimately, you need the imprimatur of a court to convert an award into judgment, and that judgment can be enforced in the local jurisdiction, which is what Kundaprapat was talking about. But you also engage the court in this regulation of awards to ensure procedural fairness, and you go to the court to apply for things like setting aside when you believe that fairness was not achieved, the process was flawed, leading to an award that went against you. That's when you engage the courts. Now, it's the courts of the seat again, and that's specified typically in your arbitration agreement. Now, if your seat is Singapore, you'll have to sort of know what kind of courts you're dealing with in Singapore. So what's the judicial policy in Singapore? Singapore is many people, it's now become a leading hub for arbitration. It now rivals, I suppose, the very best, like London and Paris and so on. Historically, those were the seats you'd go to for international arbitration. But Singapore has emerged as a very, very powerful alternative, particularly in Asian-related disputes. In fact, that's the very reason why we are having this webinar, because we're talking about Singapore as a venue and engaging the Thai market in this respect. So when you think about what the seat does. What do the courts in Singapore, what's their approach to arbitration? It's there to facilitate and promote arbitration. And that's not just rhetoric, that's actually case law. You can see a quote in the third bullet point, which comes from a case. And in the reasoning, you would see how the courts bend over backwards to uphold arbitral awards to ensure that the parties get their bargain of going through a proper arbitration. And what does that mean? Promoting arbitration from a court point of view, it means that you have to limit your curial intervention. Limit your intervention, and that acknowledges it acknowledges the primacy, sorry, it's a typo, which ought to have been given to the dispute resolution mechanism that the parties have expressly chosen. So you do not interfere because the parties have chosen a dispute resolution mechanism called international arbitration to take their dispute away from your arena into that of international arbitration. It's a private dispute mechanism. So for that reason, you limit your intervention. You don't start mucking about with it and poking your nose into it and supervising it unnecessarily, because that's not what the parties want. The parties, through party autonomy, through freedom of contract, have decided to take it elsewhere. But limited doesn't mean no curial intervention. The court's oversight and intervention is necessary to protect the integrity of the arbitral process. And that's something that is very, very important to sort of understand. That even if you have bargained to take the matter away from the courts will still want to protect the integrity of the process, the fairness, procedural fairness element of the process. And that's something that every seat does to differing extents. In Singapore, it's I would say a pretty good balance between not intervening and intervening when it matters, when you should. Some jurisdictions are more interventionist unnecessarily, and as a result, they don't make good hubs for international arbitration. So it's that sort of balance that you're looking for. Next slide. Yeah, so a couple of points which I'd already made about engaging the domestic courts of jurisdiction and what a seat is, which may or may not be different from a venue. A seat is a juridical concept. A venue could be a physical concept, but very often venue and seat are identical and can be used, depending, of course, on the context, interchangeably. But they can be different as well. You could have your seat in Singapore and still have your arbitration physically located, the hearing and so on, in, say, Bangkok. But what matters is from a juridical point of view, from a legal point of view, in assessing, what the courts are going to do in setting aside and so on, is to look at where the seat is as opposed to where physically the arbitration is being held. So if it's seated in Singapore as a matter of contract, the Singapore courts get engaged. Now, so therefore the laws on that jurisdiction are very important. And you could see that from the Queen Mary survey. This is the Queen Mary White and Case survey. They do that every now and then, I think 2 years. They come up with a survey, where they engage the international arbitration community and they look at arbitration as a service and sort of assess what is important to the customer. And you could see that from their survey, the general reputation and recognition of the seat was the very top reason for choosing an arbitration, for choosing a jurisdiction. It's important, for a seat to have that, and part of why a seat has that reputation and recognition is its ability to navigate these sort of tricky issues of how much it should intervene to set aside or not. The good ones know how to do it. The ones that are not so good are not so able to do it. As a result, their reputation falls, and people tend to sort of not use them so much. And Singapore, from the survey, is the third most preferred seat. So obviously feel that we must be doing something right. I think we've got that balance right. Next slide. So what are the grounds for setting aside under Singapore law? Singapore has adopted the model law. It also has its own arbitration act. So the grounds are set up in both. The model law has the force of law in Singapore, And Section 24 of the International Arbitration Act also sort of talks about the various grounds for setting aside. So generally, the grounds are invalid arbitration agreement. So if the arbitration agreement often is invalid, you can set aside award. Remember that it's the jurisdiction of the tribunal. The very power to be able to sort of produce an award comes from contract. So if the contract is invalid, I mean, that jurisdiction must be invalid as well. The award deals with dispute outside terms, submission to arbitration, the procedure not in accordance with parties' agreement. It's not arbitrable, it's a public policy, or it's induced by fraud or corruption. My colleague after this will go into the various grounds in a little bit more detail, but you can kind of see how these grounds work. I mean, they're largely about, they go to the very root of consent and so on. And also, they deal with certain issues that are of such fundamental importance that if you do not apply them, it means that somehow you're going to have a process of arbitration that is severely tainted. So that's broadly, what all these grounds represent. And then there's the breach, then there's the rules of natural justice at the end, which is what I'm going to say a few words about. I mean, you've often heard possibly this expression natural justice. So you think of it as a kind of, some sort of version of justice and, some general point about how justice needs to be served, bearing in mind, obviously, that arbitration involves a kind of, it's a quasi-judicial function. You're getting somebody to sort of listen to arguments and review documents and come to a conclusion on who's liable and who's not, So there's some element of justice that is embedded in your notion of things. But from a legal point of view, natural justice has two fundamental pillars. It's a right to an impartial tribunal. In other words, the tribunal cannot be biased. A tribunal must be fair and impartial. And the second branch of natural justice is the right to be heard. So that goes into procedural fairness. Every party must be given an opportunity to be heard, and only with that opportunity to be heard can a tribunal come up with a fair award. Because otherwise, the issue of fairness in respect of the award is called into question because you may not have heard one party or the other. And in setting aside the application, the applicant must show which rule, is it impartiality or is it the right to be heard, how it was breached, how the breach was connected to the making of the award, and how the breach had prejudiced the rights of the applicant. So these are the components. There must be causation between the breach and the making of the award that results in prejudice, and only then will a court step in and set aside an award. So very quickly, the alleged bias on part of tribunal, I mean, the different species of bias. There's actual bias. So if you can sort of show that a tribunal member was actually biased, that he maybe said so on the record, that I actually prefer a company of a particular nationality, and I dislike, for instance, companies of another nationality, and nationality X and Y were basically parties to the arbitration. Now that's actual bias, and if he says that and it's on the record, the arbitration is then tainted, obviously, because he's not going to be fair, and you can apply to set it aside. Imputed bias is a little bit more difficult because a tribunal member may not actually think he's biased, but somehow you can impute it to him on the basis, for instance, that he may have a financial interest and so on in the one of the parties. Let's say he's a shareholder of one of the parties who's a public company. He stands to gain from a result and so on. So he may not actually be biased. I mean, he may try his best to be fair, but there's still this issue of imputed bias. And there's certain rules that have developed around that, and guidance can be sought from the IBA guidelines on conflict of interest, which has a green list, which tells you that there may be some situation where there's possible connection, but it's no big deal. There's bias can't be imputed. Orange list, where there's a possibility that there is, and you may need parties' consent and so on, or he has to make certain disclosures. And a red list where whatever he does, disclosure or anything, I mean, it just can't be done simply because the circumstances are such that you can impute bias. And finally, the third species is apparent bias, which is a perception of bias based on the surrounding circumstances. For instance, a tribunal that enters into the arena and plays an inquisitorial role excessively. So it takes over the advocacy of a case and on behalf of one side and sort of pushes that. You can say that there is there's an apparent bias. There's a semblance of bias simply because that's not the role of a tribunal. You can ask questions, but you don't go and advocate a particular line for any of the parties. Neither should you get into the role of being counsel. And that's something that crosses the line. So what is not bias is making errors of law and fact. There are cases that talk about that. We've cited TMM division. It tells you that, even if the tribunal has made a very bad mistake, that doesn't mean bias. Bias means something more, which you've got to prove, not just getting the conclusion wrong. And just because the tribunal has indicated that it may draw adverse inferences from a party's conduct or allegations, that's not bias, because he's entitled to do that. And by stating it, it doesn't mean that he's lost his impartiality. So bias is a very, very difficult thing in practice to establish, I could say. So that's something that when it's there, comes out in a fairly big way and is quite fundamental, but it's difficult to establish. Next slide. The more common sort of ground for natural justice is no opportunity to present your case. And here, that's where one party says that, that he sort of didn't have a chance because, for instance, he was not given reasonable notice of the other party's case and didn't have an opportunity to respond. And in a case that we did, JVL Agro, that was, where we successfully set aside an award. In Singapore, there's arguments of no opportunity to present the case come up from time to time, but the success rate is not very high because in most cases, the courts do not want to intervene. But occasionally they will, and in the case that we ran, they did. And it was a very messy, complicated case involving price averaging contracts for the sale and purchase of palm oil and so on. And the defendant only ran one defense, which was there was some uncertainty of terms, and therefore there was no contract for our client to sue upon. That was broadly his argument. And the tribunal dismissed that defense. They said there was a sufficiently clear contract, but went on to find there was a collateral contract that varied the terms. Now, nobody had run this argument during the hearing. The tribunal decided that, let's go on and talk about that, and they thought that that's what happened, without giving us an opportunity to be heard, and the other party didn't even run that defense. So it went to the High Court, and the High Court set it aside on the basis of that's a breach of natural justice because we were not heard, and it didn't form one of the points of of the defendant's pleadings that collateral contracts were there to sort of vary the terms of the contract. That argument was never run, was never in play. And so that's, it was a nice win for us on that one. And finally, I think on that slide, one of the things that you do have to show is actual prejudice and so on, and it's only meaningful breaches that will cause the court to intervene. So things that are technically possibly a breach and so on that have little consequence are, these are all things that the court would disregard. That it must be something quite substantial, something that actually causes prejudice and so on. So a case on point was LW Infrastructure, where there was an argument that, in relation to a pre-award interest, and this was not the tribunal gave the party about 3 days notice to deal with this this particular point that was raised, and the court said that this was not good enough. I mean, he didn't really have much opportunity to deal with this issue of pre-award interest and set it aside on the basis of breach of natural justice. So, with that, I think you can see how it works. Courts are very cautious, but they will not hesitate to set aside an award if they actually find breach of natural justice. But the caution in this is set out in this quote from Justice Judith Prakash, as she then was. Now she's a Court of Appeal judge, very respected judge, particularly in the arbitration space. The courts are very sensitized to, how creative parties in the council are, to sort of, basically they are not happy with the result and they want to get into a substantive appeal, and they're really going for the errors of law and fact. But they use a very creative approach to sort of disguise it as a breach of natural justice, typically, some kind of form of not being given a reasonable opportunity to be heard. And, the courts are very wary of that. The courts will look at it very, very closely, and they will only intervene and give you what you want if there's really a case with all the preconditions of prejudice and so on. So it's not easy to get in Singapore, but having said that, it's not impossible either. I'm going to leave it now to my friend Jun Xiang, my colleague, who will speak about some of the other grounds for setting aside. Thank you very much.
Thank you very much, Prakash. So on the other grounds, I mean, you will appreciate that when it comes to setting aside the number of factual scenarios, it's just almost infinite. But there's some broad categories that parties do try to come under. One big one is an invalid arbitration agreement. So Prakash mentioned earlier, at the end of the day, arbitration is about consent of the parties. It stems from contract. So if there was no agreement to arbitrate or an invalid agreement to arbitrate, then the very jurisdiction of the tribunal is called into question. There are, again, it's impossible to go through all the infinite possibilities of how arbitration clauses are drafted. A couple of examples have been put up there, and they come from cases that went before the Singapore courts, which are called pathological arbitration clauses. So either it talks about using an arbitral institution that doesn't exist, or it talks about using the SIC but a different set of rules. So there are complications as to how the arbitration is going to be run. I think the takeaway, and in both these cases, the court actually upheld the arbitration clause, even though it was pathological. And the takeaway here is really that the courts will do what they can to uphold the parties' arbitration agreement. So just because it's a defect doesn't mean it's gone. The key is whether or not the defect can be remedied through agreement of the parties or through some sort of practical means. Okay. So the other broad category of setting aside applications.
Jun Xiang, I'm sorry to interrupt, but I think you may be on mute there. So I just muted just for the last 20 seconds or so.
Hello, sorry.
Much better. Okay, thank you.
So, apologies. Let me just. Just on the arbitration agreement, sorry, I'm not going to repeat what I said just now, but there are pathological arbitration clauses where there's a reference to either arbitration institution that doesn't exist, or it refers to a particular institution and using a different set of rules. So these are the examples on the screen are taken from actual cases before the Singapore High Court. In both the cases, the Singapore court actually upheld the validity of the agreement. And the takeaway really is that the court will do what it can to uphold the parties' arbitration agreement. Right. So just moving on to excess of authority, that's another broad category of setting aside applications or grounds for setting aside application. Generally, this is where there was a dispute raised that either the tribunal didn't deal with, or the tribunal dealt with something that parties had never raised. So the case that Prakash mentioned earlier, JVL Agro, had elements of this, and quite often arguments on excess of authority overlap with arguments on natural justice. So one of the issues that crops up in this kind of cases is how to determine what was submitted to the tribunal. So the starting point is always the pleadings, then we look at the list of issues that were submitted, the witness statements, submissions, and the oral hearing itself. Now, if under the SIAC rules, if you have chosen the SIAC rules to govern your arbitration, the tribunal has an express power to decide, where appropriate, any issue not expressly or impliedly raised in the submissions or in the pleadings of the party, provided the issue has been clearly brought to the notice of the other party and the other party has been given an adequate opportunity to respond. So again, you can see that a lot of that kind of language is the same kind of language that crops up in natural justice type of cases. A case that we recently did is, which was reported decision, where we resisted a challenge to an arbitral award brought on this ground. So Himalaya Food International versus Simplot, it was last year. I mean, the dispute, it was a long drawn arbitration. It took 4 or 5 years to resolve. Boiled down, it concerned certain potato processing equipment that was sold. And the contract for sale actually contained certain representations as to the quantity of the potatoes that were supposed to be produced. But in the arbitration, parties addressed also the quality of the potatoes that were produced. In the award, the tribunal made findings on quality, and then the respondent tried to set aside that tribunal exceeded its authority, and that was rejected by the High Court. Just to gallop through some of the other grounds, because we're running low on time, defects in procedure. These are situations where the parties' arbitral or the agreement on how the arbitration is to be conducted was not followed. Very often is to do with composition of tribunal. Either the requirements were not met or the number of members was wrong, that kind of thing. One interesting quirk of Singapore law is that where there are pre-arbitral steps, multi-tiered dispute resolution clauses. So where sometimes it's getting more popular, where there's a first tier, you have to negotiate between the parties, it escalates to mediation, then it escalates to arbitration. Under Singapore law, these steps must be strictly complied with. So if there are 3 steps to be followed, you have to follow strictly all 3 steps. If the steps specify specific persons to turn up for negotiations, those specific persons must turn up, or it goes to the tribunal's jurisdiction. So arguably, substantive compliance is not enough under Singapore law. Again, just to quickly run through the last few, arbitrability. I mean, sometimes as a matter of law, certain issues or certain disputes cannot be arbitrated, and very often these deal with public matters or has public implications. So the usual example is criminal matrimonial matters. Clearly, those are not arbitrable. There are gray areas when it comes to competition, corruption in the context of a civil claim, fraud or civil fraud, insolvency, that's a big one. So there was when companies are or disputes are raised in the context of insolvent companies, there's a wider public element than just the 2 parties to the dispute, because it affects the creditors at large. Okay. Then the last 2 is basically public policy, and after that there'll be fraud and corruption. Public policy grounds, in some jurisdictions, public policy is defined extremely widely. So anytime somebody needs a setting aside application or wants to bring a setting aside application, the first port of call is a public policy type of argument. But in Singapore, it is very narrowly confined. We are talking about issues that shock the conscience or are injurious to the public good. It violates the forum's most basic notion of morality and justice. This is the kind of language that the courts use. So it's not something that's easy to come under. Manifest areas of law, or even patent illegality, are not necessarily contrary to public policy. There was a case here which showed some intersection of Thai law and Singapore law, AJT versus AJU. In that case, it actually was set aside. The award was set aside on the basis that it would be illegal under Thai law to uphold. The settlement agreement also had certain terms as to the plaintiff had to withhold from making criminal complaints in Thailand, and it was held that that kind of thing cannot be upheld as a matter of law. All right, and then we come to fraud and corruption. Again, this is extremely rare in Singapore. We don't have much of that kind of thing tainting the system. Having said that, very recently there was a Court of Appeal decision 2021 which talks about procedural fraud. So if there was a procedural fraud, like where documents were concealed or there was perjury in the evidence taking, then in the right circumstances, that could possibly be a basis for setting aside an award. On the facts of the case, the court found that there was no such procedural fraud. They found that the claimants had not reached that level of egregious conduct. However, I mean, the door has been opened to that kind of argument. So, you know, it remains to be seen whether or not in future cases this would be something that parties try to push. So just to conclude very quickly, I mean, a lot of these points were made by Prakash earlier. Setting aside of an arbitral award is not something that's easy to do in Singapore. We do have a judicial policy of minimum curial intervention, and the courts are extremely vigilant against parties using the setting aside procedure as backdoor appeals. At the same time, they will not hesitate to intervene when there's a defect in the process. Yeah. And I mean, there are overarching concepts of procedural fairness. All right, with that, hand over to my colleagues back at Tilleke and Gibbins.
Hi, good afternoon, everyone. My name is Fawad. I'm going to talk about Hello. Okay, I'm going to talking about how Thai court recognize and enforce or to set aside the arbitral award. Okay. Recently, the Supreme Court judgment confirmed that the Thai court has no power to review the case merit. For instance, the arbitral tribunal concluded that party A breached the agreement, then the court had no authority to adjudge otherwise. Nevertheless, if the court viewed that the enforcement of the award would be contrary to the public order, the court will refuse to enforce it. I will show you one example. It's a Supreme Court judgment number for your reference. It's the Supreme Court judgment number 6741 of the year 2019 or 2 years ago. According to the judgment, the two plaintiffs delivered the car to an entity named Saw Partnership Limited on December 18, 2013, and on December 22, 2019. And in the beginning, the two plaintiffs received the rent under the contract. Thereafter, the two plaintiffs did not receive the rent. Therefore, the two plaintiffs were aware that they were cheated. Thereafter, the criminal legal action was taken against the offenders. The court of first instance rendered the judgment to punish the offender in the charge of cheating and fraud. It shall not, the court said that it shall not be deemed that the date that the two plaintiffs delivered the car were the date that the offense was completely accomplished, which would be held at the date of loss, which will have an effect that the two plaintiffs file the statement of claim after the lapse of 2-year prescription period according to the arbitral award. So, if such award is recognized or enforced, it shall have an effect that the two plaintiffs lose the interest, because according to such fact, such facts, it shall be difficult to a reasonable person to know that they were cheated from the date that the car were delivered under the contract. Therefore, it shall not be deemed that the date of loss commenced from the date that the car were delivered under the contract. Then the arbitration award is contrary to the public order or good moral. It can be seen that there is a cause to revoke the arbitration award according to Section 40 of the Arbitration Act. This is a good example that sometimes, in my view, according to this Supreme Court judgment, it seems to me that sometimes the court re-examine the substantive merit or the case merit through what the court say that what the court call is a public policy. But we may think I think otherwise, but it was the Thai court rule. The second case or second Supreme Court judgment that I want to mention at this presentation, this is about how the Thai court set recognize or set aside the foreign arbitration award. This Supreme Court judgment was made 3 years ago in 2017, and for your reference, it's the Supreme Court judgment number 8539 of 2017. This is the case between two parties. I want to call the Thai party and the UK party. This is a long story. This is about the long story, but at the end, I understand that we will provide you the PowerPoint presentation for more detail and for your reference. According to the Supreme Court judgment, Thai party received a final award from the what I want to call it UK arbitration in relation to the breach of the sale and purchase agreement between English party as the claimant and the seller of the cotton, and the Thai party as the respondent or the buyer. The final award is favorable to the UK party by ordering the Thai party to pay outstanding cotton price and compensation about 77 million Thai baht. Then Thai party submit an application to IP and IT court in Thailand to set aside the state award due to Thai party say that the award is contrary to the Thai public policy. I want to say that this is case number 1 initiated by the Thai party. Then in the same time, UK party submitted another case to the same court. I don't know how it happened. The UK party submitted another case to the IPIT court, requesting the court to recognize and enforce the award against Thai party. I want to call this case number 2 initiated by Thai party. According to the judgment, the UK party did not know that Thai party request the court. In UK party did not know that the Thai party request the court to set aside the award in the second case, in the first case. And the Thai party knew that UK party request the court to recognize and enforce it. Thai party, the Thai party try to delay the court procedure in the case number 2 by requesting mediation in the court to delay. This very general tactic in Thai court to delay the case. Then the case number 1 initiated by Thai party proceed faster than the case number 2 because the UK party did not appear in the case number 1 or default, you know. Then the IPIT court rule to set aside the award, you know, be it for the case that initiated by Thai party. UK party for the case that initiated by the UK party, you know, during the court proceeding, the Thai party, you know, they submit an evidence to the court, requesting the court to dismiss the UK petition, saying that the award was set aside, you know, that the award was set aside. Then the court in the second case, you know, that initiated by the UK party, agree with the Thai party and refuse to enforce the award, you know. Then UK party appeal the IPIT court judgment to the Supreme Court, saying that Thai court had no authority to set aside the foreign award. Sorry. And in this case, the appeal, then the Supreme Court in this case ruled that according to the law, according to Thai Arbitration Act, Thai court, Supreme Court confirmed that Thai court had no authority to annul or to set aside the award made by in the foreign country. So this is what they are in according to the slide. Kunmu, can you move to slide section to page 26? I want to move the conclusion. There are some yes, right. Yes, according to this Supreme Court judgment, I think the most important issue is that Thai court, I think, recognize and enforce the foreign arbitration award, but Thai court want or cannot or have no authority to set aside the foreign award. I think this is important to know that if Thai court saying that if you the losing party want to set aside the foreign arbitration award, they have to go to the country where the arbitration is seated. This is my conclusion. So, Kunmu, please.
Okay, thank you, Khun Thawat. Actually, this is something that we share with you about 2 cases in the Supreme Court. But the latest case that Khun Thawat referred to, the Supreme Court judgment confirmed that Thai court have no authority to annul or set aside the foreign award. Is something that that is quite important, and that's why I raised this issue at first, that if you are the winning party and you want to enforce the award in Thailand, and if it is not a lot of cost for you to register the award in the seated country, then I think that please just proceed register the award with the court, before you come to enforce the award in Thailand, and then we have the confirmation from the seated country that okay, this award haven't been announced in the country that is issued. So that's all we have. Even though we have two additional topic, but we think that with the limitation of the time, we keep it simple here, and we're going to have the another seminar in Thai concerning the same topic, and then we will inform you about the date and time when we have this topic arranged, and we'll invite you to come to join us. Okay, for today, we thank you our colleagues Pakat and Jun Siang from Clyde Co that joined the discussion with us today and sharing the very useful information and knowledge concerning the setting aside in Singapore with our team, and we hope that we both team will have a chance to do the webinar like this in the future. So okay, the moderator, should we left the forum here, or Pakat, you want to talk anything before we leave the forum?
And may I just suggest at this stage, I'm very aware of the running over a little. Perhaps we could just handle one question before we close the webinar off for those who are keen to hear. I see we've had one published already. So I wonder if we could just address that question there. Prakash?
Okay, I'm just looking at the question. Is it a good way to go if neither party to the contract is a Singaporean company and also no ties whatsoever to Singapore? The contract was agreed that way to use Singapore arbitration simply because it's a third-party country for arbitration. What is your thought on this, or any recommendation, is the question. That's a good question, actually. It sort of draws into play the whole idea of neutral venues. So in arbitration, what very often happens is that it emerges from cross-border contracts. So if you, for instance, have a Thai company, you've got a contract with an Indonesian company. Now, one point about arbitration is your desire to avoid court litigation, and as a sort of as a wrinkle on that, you also would want to avoid litigation in the other person's country, because if you do that, if you agree to litigation in the other person's country, your counterparty's country, you may feel that you're giving your counterparty an advantage over you, because it's going to be in their language, it's going to be their system, it's going to be they have home ground advantage. And if you were a sportsman, you would sort of know, whether it's football or cricket or rugby or whatever, you would know, how powerful a home ground advantage is. So arbitration is the same sort of thing. I mean, you would, you don't want to go to each other's country. You don't want to make that the seat, because again, you think you're giving the courts of that country an opportunity to engage, and as a result give your counterparty an advantage. So you look for a neutral venue, and that's very, very common as a model. And when you do that, you've got to sort of see what kind of neutral venue you're looking for. I mean, typically what you would look for is a place, a seat, which is very, very familiar with arbitration laws, very familiar with arbitration norms. It has a culture of respecting party autonomy and minimal sort of curial intervention, with the need to supervise and regulate to the extent that you're trying to ensure procedural fairness and the integrity of the system. in other words, a good system on the books. You've got to have, your seat has to have good laws, good rules, as well as the application of those rules must be done properly. So you need courts that are familiar with these things and are very, very good at supporting arbitration as opposed to blocking or obstructing of the objectives of arbitration. So from that point of view, I mean, Singapore is one reason for Singapore's success is we have got that legal infrastructure, and it's one reason why parties from all around the world, even if they have no ties to Singapore, they use Singapore as the seat for arbitration. I mean, my colleague Jun Xiang just spoke about an arbitration we did, Simplot. It was against an Indian party. Again, the project was in India. It was governed by Indian law. We acted for an American party against an Indian party. The only connection to Singapore was that one line that said seat of arbitration in Singapore. So you can see, that's how arbitration works. You use neutral venues and you choose your neutral venue on the basis that the neutral venue is able to kind of, support the arbitration effectively. And Singapore is a good, a good center for that.
That's excellent. Thank you very much. So as we round to a close on this webinar, I'd like to thank all of our speakers today, from the Clyde Co side, Prakash Pillai and Judicial Co, and from Tilleke Gibbins here in Bangkok. Thank you to Nopramat and to Tawat. Thank you all, and we look forward to seeing you at the next webinar. Thank you.